Good morning. My name is Sonia O'Loughlin and I work in the Environmental Assessment team with the EPA. Today I'll be presenting on the requirements for EIA and retrospective EIA as they apply to the new abstractions regime. This presentation aims to clarify the circumstances under which abstractions and associated impoundments may require an EIA or a retrospective EIA, and to outline the requirements relating to these. In this presentation, I'll introduce you to EIA and retrospective EIA in the context of the abstractions regime. I'll cover key requirements associated with these assessments and explain when they are applicable and when they are not. At the end of this presentation, I'll also briefly touch on appropriate assessment as it applies to the abstractions regime. As covered earlier by Jim, water abstractions and associated impoundments are regulated by the EPA in the form of a registration, licensing and control regime. Water abstractions and associated impoundments which require a license may also require EIA under the EIA directive. The EIA directive is an important piece of EU environmental legislation, and its main purpose is to ensure that projects that are likely to have significant effects on the environment are subject to an assessment of their likely impacts before consent is granted. This assessment is known as an EIA, an environmental impact assessment, and is a process involving screening, scoping, submission of an EIAR, an environmental impact assessment report, consultations by the competent authority with specified bodies involving the inclusion of public participation, the examination and evaluation of the EIAR by the competent authority with the reasoned conclusion considered in the decision of the competent authority. The legislation governing the abstractions regime provides for both EIA and retrospective EIA. In the context of the abstractions regime, EIA is a process involving the examination of the expected environmental effects of a proposed abstraction or associated impoundment. Retrospective EIA is a process involving the examination of the environmental effects which have occurred, which may be occurring, or which can reasonably be expected to occur due to an existing abstraction or associated impoundment. EIA or retrospective EIA requirements for the abstractions regime are summarized here. EIA or retrospective EIA considerations is a term used to summarize the assessments undertaken by the EPA, which are listed here. These assessments will apply to either certain entries on the register or certain applications for a license. The corresponding documentation or information to be submitted to the EPA is also listed here. More information on the documents to be submitted to the EPA can be found in the EPA Registration and License Application Guidance document. However, EIA or retrospective EIA considerations won't apply to all abstractions. The EIA project types that the EPA considers directly relevant to the water abstractions regime are listed in Appendix 1 of the EPA Technical Guidelines on Retrospective EIA, shown here. These directly relevant project types apply to both EIA and retrospective EIA. EIA or retrospective EIA considerations will only apply to the three types of abstractions listed here. Groundwater abstractions, surface water abstractions with an associated impoundment, or surface water abstractions involving works for the transfer of water resources between river basins. To be clear, surface water abstractions, whether they be existing or proposed, do not fall within a directly relevant EIA project type and will not be subject to EIA or retrospective EIA considerations unless there is an associated impoundment or unless there is works for the transfer of water resources between river basins. Something to really emphasize is, regardless of any other associated activity, if your abstraction or associated impoundment does not fall within a directly relevant EIA project type, your registration or license application for an abstraction will not be subject to EIA or retrospective EIA considerations. For example, in the situation where there's a piggery, which is an EIA project type, that involves a surface water abstraction, which is not a directly relevant EIA project type if it doesn't include an associated impoundment or a transfer of water resources between river basins, the registration or license application for that abstraction will not be subject to EIA or retrospective EIA considerations. In relation to retrospective EIA considerations in particular, the EPA has published technical guidelines which include a section on the categories of abstraction not likely to be subject to retrospective EIA considerations. This section should be referred to by anyone with an existing abstraction or associated impoundment which falls within a directly relevant EIA project type. If an existing abstraction is of a category listed in Section 5 of the Retrospective EIA Technical Guidelines, then it's not likely that retrospective EIA considerations will apply. In this instance, evidence is to be submitted to the EPA in support of this for a registration or license application. EIA project thresholds relate to the volume or area specified in each directly relevant EIA project type. The thresholds that relate to the abstractions regime are highlighted here in yellow. If the abstraction or the associated impoundment equals or exceeds the threshold of a directly relevant project type, then mandatory EIA or retrospective EIA is required. If the abstraction or associated impoundment is below threshold, that is to say it's sub-threshold, then the EPA will assess whether EIA or retrospective EIA is required. Sub-threshold entries on the register will be subject to a preliminary assessment and/or a screening assessment by the EPA, and sub-threshold license applications will be subject to a screening determination by the EPA. As covered by Jim, abstractions between 25 and 1,999 meters cubed a day must be registered. As covered by Pat, once registered, abstractions will automatically be subject to an assessment for significance. If the abstraction is not deemed to be a significant abstraction, it will then be assessed further by the EPA to determine if EIA or retrospective EIA is required. As a result of a preliminary assessment and/or screening assessment, the EPA will determine that either EIA or retrospective EIA is required and therefore a license is required, or that EIA or retrospective EIA is not required and a registration number will be issued. For license applications, these will need to be submitted under a certain section of the Act, depending on whether the abstraction is subject to either EIA considerations or retrospective EIA considerations. Apply under Section 21 where a proposed abstraction has EIA considerations. Apply under Section 29 where an existing abstraction has retrospective EIA considerations. And apply under Section 37 where an existing abstraction has retrospective EIA considerations and there is intent to vary or increase this abstraction. Assuming that the abstraction or association empowerment falls within a directly relevant EIA project type, and depending on whether it's below or above the threshold, the scenarios shown here will develop. If the abstraction or association empowerment is sub-threshold, the license application will be subject to screening by the EPA. If it's determined that EIA or retrospective EIA is required, then an EIA-R or a retrospective EIA-R must accompany the license application. If the abstraction or association empowerment equals or exceeds the threshold, EIA or retrospective EIA is required, and an EIA-R or retrospective EIA-R must accompany the license application. As EIA applies to abstractions under the EIA directive, so too does appropriate assessment under the Habitats Directive. AA is an assessment of the potential adverse effects of a plan or project in combination with other plans or projects on special areas of conservation and special protection areas. Under the Habitats regulations, prior to granting consent, the EPA is required to undertake screening and, where necessary, undertake appropriate assessment of any plan or project for which an application for consent is received. As such, each application for a water abstraction license should be accompanied by an appropriate assessment screening report and, where necessary, a Natura impact statement. Here's a list of links to some useful guidance documents. Thank you for listening today, and I look forward to any questions you may have.